Welcome. We've got a lot to get through this afternoon, so we're going to try and start quite promptly. For those of you who don't know me, my name is Kolvin Stone. I'm a partner and head of technology at Fox Williams. So with a national crisis averted last night, congrats to the English football team. We turn to another crisis. Ransomware attacks are on the rise. This past weekend, it was announced that up to 1,500 businesses around the world have been affected by a ransomware attack centered on US information technology firm Kaseya. So the hackers who claim responsibility for the breach have demanded 70 million to restore all of the affected businesses' data. So this is a serious and business critical issue. So we are delighted to be able to offer with Kroll, one of the world's leading cybersecurity firms, this crisis simulation, which will help you understand the key initial steps and issues you need to take in the first couple of days to deal with an attack. So helping us with this workshop are some industry experts. We have Ioan Peters, who is the managing director at Kroll. Ioan will be our lead narrator and also play the role of CISO, Chief Information Security Officer. Lin Chua, who is Vice President and Privacy Counsel at NBC Universal, and was also Tech and Privacy Counsel at Citi for 11 years, which is very relevant because the scenario that we're talking about is a regulated firm. Lin also had the dubious pleasure of being my mentor when we worked together at Fox Williams when I was a trainee. And Lin will play the role of our General Counsel. Simon Pugh, who we've lost temporarily, but will hopefully join us in a minute. He works at Portland Communications and is an expert in crisis comms. And last but not least, David Butler is playing the role of external counsel. David is head of fraud, civil fraud at Fox Williams. I will also play the role of non-executive director to help facilitate the board discussions. If you have any questions, please feel free to pose them using the Q&A function. And if we have time, we may not, but we'll try and deal with them at the end. If not, then we're happy to follow up separately. So now over to Ioan, who will take us through the simulation.
Thanks very much. So this is going to be a bit of fun for us, but really not for these guys in Acme Limited. So we've made up a company, but actually this is really realistic. It's based on a conglomeration, amalgamation, whatever you want to call it, of some of the 2,700 incidents that we respond to annually. And it's pretty typical of a ransomware attack currently. So responding to this kind of incident that places a company in jeopardy is so much more than a technical problem. It really involves the whole of the business, the board, business continuity arrangements, counsel, internal, external insurers, people like me, incident response specialists, etc., crisis comms, and so on and so on. So we have the various roles who will join in the format of a board meeting to give you an insight into the kind of inner workings of the company and some thoughts on the direction. He is responding to this type of scenarios, never really based on fact, unfortunately. It's based on best effort judgment at points in time based on the available information. So it's actually really tricky. And it's that kind of jeopardy that we want to bring into this workshop today. So Acme Limited is a medium-sized company. It's financial services, specializes in structuring finance for high net worth individuals. As the data it deals with is pretty sensitive. Also works for other companies and multinationals alike. The board members are having a great morning so far because they're working on IPO. So the valuation of the company is front and center of their minds. And really, they're pretty easygoing. Disasters happen to other people, not them, and but they have bought insurance as a backstop. So cyber insurance is something they did invest in, fortunately. So incidents often happen, or the first stages of an incident often occur as just an IT glitch, really. Something's not working, something's not correct, feels wrong. Maybe you get a blizzard of calls in through the help desk, people saying something doesn't work, can't get at my information, can't really use my laptop, something's wrong. the calls start flooding the IT people. Maybe instant messaging starts being choked up with what's going on, who's doing what. It's pretty early in the morning, so not everyone's around to deal with this right now. And really IT begins investigating to try and find out what the hell is going on. So at this point in time, how does IT really put this together and decide when an incident is critical, is going to have a meaningful impact on the business and isn't just a team or a bunch of users that are experiencing limited difficulties? How do they really communicate with people when things aren't working properly? They've had some phone calls, they had some IMs, but increasingly it's getting difficult to use the technology because they themselves are suffering some availability problems. And how really do you focus on investigating the technical side of this when there's a blizzard of noise around you? Just to compress time a little to run this today, we'll arrive at a nasty discovery. IT find a ransomware basically and think that they have ransomware. So the initial thoughts of any technical team at this point, the heart really sinks. Is it spreading? How do I limit it? What's going to be the impact? Who do I tell? How do I tell them? Have we got backups? Are the backups valid? How on the earth are we going to restore the whole company from backup, potentially? The business really is in trouble and it can't really work. So we can't respond to clients who are calling us. We can't access email. Nothing is operative. So IT needs space to work, but they've rapidly got a queue of people waiting for them, calling them, trying to get hold of them. In pre-COVID times, probably waiting outside their office and so on. So this is a pretty typical example of a ransomware note. So it basically describes that the information is encrypted. It asks for somebody to get in touch and makes a threat. If you don't get in touch, something bad will happen. In this case, they'll upload the data to somewhere and publicly shame them. So the IT director at this point really thinks that a board meeting's needed. The board are used to working together, so that isn't much of an issue. But it is really quite difficult to call the board together or any group of people together when you haven't got the IT to do it. You haven't got the usual conferencing system and so on and so on. So the IT director is kind of left to scrabble around on a mobile phone, trying to get people into the same place at the same time, find the conferencing system somewhere that they can use, send out invites and so on and so on. And all of that really takes time. She's really worried in this case because the note infers quite strongly that data has been stolen. So what's going to be the impact of that? It really puts pressure on any technical team and indeed the business to find out, what's happened, what's gone wrong, how do we deal with it, what's the impact? This note is really useful from an incident response perspective as well, because it helps people like me understand who might be involved at the other end. Is the threat credible? What are their typical behaviors and are they sort of weirdly honorable to deal with? Because obviously this is a business for some criminals, and therefore there is a code of conduct because people need to be able to trust them in order to be incentivized to pay them in order to get their data back effectively. So we'll move rapidly to the first emergency board meeting for some thoughts. But IT's confirmed at this point that systems are encrypted rapidly, help is really needed, they don't really know what's going on, laptops and servers are affected, they don't know how much because they've lost visibility basically. They're just telling people to shut everything down, try and stop the spread. And somebody helpfully suggests that, yeah, we should just pay them, it'll all go away. So we'll invite Kolvin to take us through some thoughts from the board, but basically it's now more than an IT incident. It's really going to take time and effort to investigate and work out a safe way of remediation. So over to you, Kolvin.
Thank you, Ioan. So as a board, the first thing we want to understand is our legal responsibilities. So I'm going to ask our GC, General Counsel, Lin. So I understand that certain breaches may be reportable to regulators. Is this a reportable breach? And if so, which regulators do we need to report to and when?
I would say potentially this is reportable. And just to give you some background, data breaches that give rise to risk to individuals need to be reported. And data breaches really include three sorts of breaches. You could have a breach of confidentiality, so where the personal data has been disclosed or accessed without authorization. You could have a breach of integrity, so where it's been altered. And you could have a breach of availability, where there's been a loss of access to the data or it's actually been destroyed. All of them are bad news, obviously. But in this case, it looks like we can't access systems holding personal data. So it sounds like a breach of availability, but it also depends on which systems are involved, right? Are these our core systems or critical systems that hold personal data that impact our ability to do business and service them? So at the moment, we don't have evidence that it's a breach of confidentiality, right? We have a ransom note which says that they've got the data, but we haven't managed to find out anything about that. When it comes to notifying the various regulators, the main ones we'd be looking at would be the ICO, which is the UK data regulator. And the obligation there is for controllers to notify them without undue delay, where feasible within 72 hours after having become aware. And really, the reason why the regulator wants to be notified is because they want to be able to handle sort of queries and also ask you pertinent questions about whether you're complying with your security obligations. So you're going to ask me, when are we considered to be aware, considering that all we have so far is systems that aren't working and a ransom note? Well, the answer is that we're allowed to have a short period of investigation to confirm whether or not there actually has been a breach. And it's at that point that sort of awareness is considered to have taken place. If you conclude, of course, that the breach is unlikely to result in any risk to individuals, then there isn't a notification obligation. Now we come to our other regulator, our more scary regulator, the FCA. And they expect us to notify immediately after we become aware of any matter which could affect our ability to continue to provide adequate services to our customers and which could result in serious detriment to the customer. Or if we've got any information that reasonably suggests that this has actually happened or could occur in the future. Luckily, we've divested our German offices, because if we did still have those offices, we would have to notify and deal with those regulators as well. And before Brexit, companies like ours, with the main establishment in the UK and operations elsewhere, would be able to have ICO act as a lead supervisory authority, so we wouldn't have to deal with multiple regulators at the same time. But anyway, to sum up, our immediate priority has to be for IT and security to work to confirm which systems are affected, whether data has actually been exfiltrated, removed, and whether any core or critical business processes are affected, and really whether anyone's at risk as a result of this attack. And only then will we have that information we need to determine whether we need to notify.
Thank you. That sounds quite a lot to do and only a short period of time to do it. Do you think we need external legal support?
Yes. We need to put ourselves in the best position if and probably when we need to notify our regulators and any impacted individuals. And regulators will ask for further information, and it's the responses we give that will determine whether or not they decide to initiate formal regulatory action. And unfortunately, that can result in substantial fines. So under GDPR, the maximum sort of fine is up to 4% of total worldwide turnover. Also, individuals might decide to bring claims, and we've got a number of high net worth individuals who are our clients, and it's more than possible that they will reach for the phone to call their lawyers. It's also possible that customers could band together to bring class actions. It's certainly happened before. So really, specialist external counsel can add a lot of value because they would have dealt with this before, and they can provide practical and strategic advice to help us navigate this. And this advice would be protected by legal advice privilege, which means that if there is any potentially damaging information, it would be protected from disclosure to regulators and those claimants.
Understood. It's been suggested that it just might be easier for us to pay. Is that an option? Is that something that we're able to do, or is permissible?
Well, from a legal perspective, I think we would need to take some specialist advice on this. I don't believe that paying a ransom is of itself illegal in the UK, but I do know that there are some offences that you could commit depending on who you're paying the money to and what the circumstances are. So money laundering, sanctions, terrorist financing, those are the ones that spring to mind.
Thank you, Lin. Simon, as our crisis comms expert, clearly our staff are aware that there's a problem. What do we need to tell them, and how can we communicate with them given that our systems are down?
Well, yeah, that's the first question that we would be thinking about. What is the kind of practical way for us to actually communicate with our staff if things like our emails are affected? And therefore, the key there is that we've done some pre-planning, and that actually we are able to cascade information through the organization quickly and through routes that don't rely on things like email. So ensuring line managers have potentially kind of personal mobiles that actually they can contact their staff in an emergency, which this very clearly is. And we will need to kind of give staff information that actually enables them to continue their work on a day-to-day basis as best they can. We'll also have to be reminding them of their obligations of confidentiality towards the business, and ensuring that they're not speculating on social media, for example, about what might be happening. And reminding them that if they get any inquiries from media, or indeed any kind of external inquiries, that they don't know who it's from, because potentially journalists might not immediately identify themselves, that they direct those inquiries to the press office, which will then be escalated to the board level.
Thank you. And on that note, in terms of the potential risk of it becoming public, it's obviously sort of topical at the moment. Is there anything we should be doing now, just in case it does become public?
We should be drafting a holding line if this issue does become public, and we do need to kind of give something to the media. But the important thing is this is a rapidly evolving situation, and we only want to communicate externally on the facts when we have them and when we are confident in them. What we absolutely do not want to do is speculate, because that will likely lead to some problems. And Lin has mentioned the possibility of litigation further down the line. And we don't want to have said anything now that could potentially be problematic in that sense. And therefore, it's very important that the comms team remains in constant communication with the legal advisors, and all communication is drafted in conjunction with them.
Thanks, Simon. Ioan, in terms of the investigation, what are the next steps for us? Lin said that there are a number of facts that we need to confirm.
So we don't really know how the ransomware is spreading. So as I said, we're shutting everything down. We don't really, at this point, know how they got in, because we've only just started investigating. We need space and time really to investigate and to put a restoration plan together. But we need help really to do that work. It's not something that we have the in-house resources to really do well and quickly and at scale. We're in a great position in that we've got some offline backups, so they won't be, I don't think anyway, affected by the ransomware. And we should, in theory, be able to restore from them. But obviously that'll take time and effort. And we probably need more equipment to do that, because obviously we're not really scaled to restore the whole business in one shot. Generally speaking, we'd restore a small amount of data. So we're probably going to need additional servers, additional laptops, more tape drives, and basically more hands to be able to do this in a reasonable space of time. We're looking at weeks, not really days and hours.
Thanks, Ioan. You mentioned that we need additional resources. Wheeling, can I come back to you and ask you if we have any insurance in place that we may be able to get help from our insurers?
Yes, luckily we just renewed with our insurers, and they've actually got a panel of firms that could help, so incident response firms, crisis communication specialists, external counsel, even ransom negotiators. So I think we'd better get in touch with them.
Fantastic, thank you. So back to Ioan to continue with the simulation.
Thank you. So just to summarize, really, the board decides to call the insurers, unsurprisingly, and appoint external counsel to provide advice. And discussions on payment really are paused until the board really knows more. It sounds a bit grey and a bit icky, to be honest. CSER agrees the use of an incident response firm with the insurers. IT really are under pressure to explore all options to get the company back up and running, and basically everyone is under pressure. Everyone feels pretty rotten, anxious. People often feel that they've failed in their duty, so we're really quite mindful from an external perspective when we go in and help people. Then emotionally, people might not be in a great place. Internal comms starts communicating out with internal staff and agrees the use of crisis comms with the insurer, and regulatory reporting begins to be prepared. This is hours after the initial discovery, so the amount of data available to do that is pretty limited. So we're compressing things a little more, and this is a site you never really want to see out of some kind of product launch. The media can't be on your doorstep, but it can happen, and it does happen, unfortunately. So something scrolls across the TV screen in the corner of the office whilst discussions are ongoing and people are trying to work to get things back up. Something about Acme Limited, a question mark around the company being hacked, and rumors that client data is compromised. Something that can be incredibly damaging. Just even misinformation, even if it wasn't true, and we don't know either way at this point in time, it can be incredibly damaging. And you can imagine that clients, if they see this and hear this, increasingly will be on the phone to say, what the hell is going on? And at this point in time, your corporate communications might not be functioning. So if they try and call, it's more than likely to go, going to go through to individuals and mobile phones, etc. So if you can imagine the pressure that this would cause the team trying to find out what's happened and how to deal with it. Emotionally, how staff would be feeling at this point, because everything that they've built to achieve is suddenly in jeopardy and is being criticized externally, really. What effect do you think it would have on the investigation, having everyone's mobile phone sort of ringing off the hook, people trying to find out what the hell is going on when there's really not very much information to give them at this point in time? And in the context of the business, that risk of having your clientele, and in this case, multinationals, high net worth individuals, capable, informed people, take action to try and protect their interests, try and find out exactly what's happening, probably earlier than you can credibly give them information. They might obviously reach for their litigators in turn, and that prospect of the IPO that I mentioned earlier is really gone AWOL. The valuation of a company that's just been breached would be really materially affected, because at this point in time, they're not potentially in control of their data, which is their most valuable asset, and their reputation, which is equally the enabler that allows them to do business, because they trade on trust at the end of the day. So another board meeting is called for Friday. It's a busy day. As you can imagine, the press reports really need to be discussed urgently. Though IT and security know that they haven't found anything yet. Do we really know that something's gone? How does the press know, for example? The encryption is really hampering the investigation. So systems aren't available to even be able to find information, what happened, when and where. Incident responders are providing remote support, but in practice, they'd be traveling to site at the same time. but they're only just setting up and getting access to data and spinning up because the finding of a needle in a haystack takes time. And there's more immediate concern over regulatory action because obviously if it's in the news, then the regulators might put two and two together and start asking questions as well. There's really now a fight for survival. Extensive discussions of the press reports are taking up a huge amount of time. Let's ask Kolvin really to lead us through some insights from inside the board meeting.
Thanks, Ioan. I'm delighted that we have our external counsel, David Butler from Fox Williams. David, our general counsel, William, mentioned the importance of maintaining privilege in terms of managing sort of legal risk with regulators and also potential litigants. Could you outline for us what we need to do in that regard, and also presumably the preservation of evidence is also important in this scenario?
Yeah, absolutely. So one of external counsel's principal roles in these situations is actually to ensure that the decision-making process that ACME undertakes is as far as possible protected under a sort of a blanket of legal professional privilege. There's a number of other roles that the external counsel perform. Quite often that actually, and depending on whether your external advisor is insurer appointed or your own existing external advisors who the insurers are happy to allow you to continue to use for this purpose, sort of depends on how much external counsel sort of have to ask questions and orient themselves at the start of their role, their retainer. In my experience, a lot of the sort of the first bits of external counsel's role is to find out what's going on. Usually, external counsel's role is to ensure that the company does what it needs to do in compliance with its legal obligations, and minimises its possible legal exposures as well. So there's a number of areas that covers. The first thing that Lin mentioned, of course, is that ACME is an authorised firm. So question one, has the FCA actually been notified? Because that's very important that the regulator is brought in at the earliest possible stage, even if it's only to say this has happened and we're dealing with it and we'll provide you with an update as soon as we can. There might be a series of questions that we ask simply because nobody's thought about them yet, because they're all deep in the response itself. So, for example, is the company's banking information stored on the system? Could the hackers get access to bank logon credentials, for example? Has the bank been notified? Has the bankers been notified? What sort of data do you hold about your clients? Is this banking information about them? Is it, all of their deepest, darkest financial information? If so, we may need to prioritise who gets told and when in the worst case scenario. Is there an indication about how this has happened? Is the systems, is the firm's systems up to date in terms of patches and security updates, etc.? Can we track who the perpetrators are? Ransom demands are often attributed to a group of threat actors and rarely attributed to actual real people. If the attacker is not a known threat actor, is it possible that it's an inside job? Has it been carried out with assistance of employees? How far does the breach extend across the company's other systems or the company's systems generally? At this stage, we might also be giving some thought to the worst case scenario, and there is a leak of information and a release of information, and we might be thinking about steps we can take to get court remedies to prevent the further dissemination of that information, and query whether there's been movement of that information overseas, and if we need for foreign advice as well.
Great, thank you, David. So if we decide to make payment, that's something that is certainly being considered at the moment. Is that something that we could potentially recover?
So there's three aspects to it, I think. The first is, are we breaking the criminal law by making a payment? Generally in the UK, we are okay to make the payment. We are in the regulated sector, which presents some particular issues, which maybe we'll talk about a bit later on. But for the purposes of the Proceeds of Crime Act and anti-terrorism legislation, because we don't actually know who the attackers are, we don't have any reasonable grounds to know. We don't have any reasonable grounds to suspect that we are actually engaged in the relevant commission of a relevant offence. So we're all right from that perspective. If we had a US branch, it might be different, and if we had branches in other parts of the world, it might be different because the standards are different in those countries. From a sort of internal perspective, there's also a civil law, company law question about, should the board be actually deciding to do this? And that's a relatively straightforward question from the board's perspective, and it depends on what's in the best interest of the company. That is a decision that requires some sort of careful balancing of pros and cons and some judgment calls. And yeah, all the relevant factors need to be taken into account. So, I mean, I think Ioan's already mentioned, we're looking at weeks rather than days to restore the systems if we choose not to pay. The data could be sensitive financial data, and we certainly would prefer that didn't become public. I don't know what the size of the ransom is at the moment, but the size of the ransom is a relevant consideration. And whether ACME can get reasonable assurance that making the payment will actually bring the attack to an end, and prevent the release of the information. That's part two. And then part three is actually, does your cybersecurity policy actually respond in terms of the ransom payment itself? Some do, some don't. What do you need to do under the policy to ensure that if it is recoverable under the policy, that the insurer will actually pay up? And that may mean that you need to talk you need to liaise quite closely with the insurer in relation to the payment, and the insurer might require you to contact criminal investigatory authorities as well.
Thank you, David. So Simon, the press are aware of the fact that we have been hacked. What do you recommend we do in terms of dealing with external press interest?
So I think the thing we will want to avoid in this is a vacuum forming, because often when a vacuum forms and a business isn't able to communicate, journalists will look to other people to potentially fill their story. So that could be industry kind of stakeholders, or even worse, it could potentially be our competitors who will be invited to speculate on what might happen. And therefore that we need a kind of voice in that debate. But as per the kind of previous comment, we can only communicate on the facts when we have them, and we must not get drawn into speculation. And whilst the media may well want to kind of press us with tight deadlines and fast-moving stories, we need to kind of not get drawn into that. Although our communications do need to kind of be timely, and as has previously kind of been commented on, there will be questions about whether or not we need to kind of notify regulators and which regulators. Of course, those regulators are going to be reading about this in the press. Mm-hmm. So all of the communications needs to be kind of done with that in mind.
Thanks, Simon. And on that note, William, if I can ask you, David mentioned the importance of timely notification to the regulators, and you said that we had a short period of time to carry out an investigation. Are we at the point now that we need to notify regulators?
Well, It's only been 7 hours since we received the ransom note, and we've only just had these incident responders and sort of external counsel appointed. So we're really quite early on, in our investigation.
Mm-hmm.
But on the other hand, we now know we can't access our core systems. So it does look like we have an availability breach, at least for a few weeks until we can get the backups restored. And we still have the threat of confidentiality breach. And really, it would have been better for the regulators to hear the actual position from us instead of reading those press reports. So I think it is time to notify the regulators, at least to give them that initial heads up. So I have been working with David and his team to prepare that initial report to the FCA and ICO. And, it's not going to be very long. There isn't that much to say at this point. And, so we'll be circulating a draft shortly after this meeting for us to review. And I think in terms of input, I'd like the chairman of the board and crisis communications to get back to us with any comments by the end of the day today, please. It's Friday. And we'll aim to get it out to the FCA and ICO first thing on Monday. I mean, yes, I think the time period for notifying the FCA is probably a bit shorter, but we do want to coordinate because they do exchange, they do sort of compare notes. So we want to keep them in step with each other and be very consistent in our messaging.
Thank you. And once we make that notification, what do you see as the impact of that and the next steps? And do you foresee any consequences for us as a result of making that notification?
Well, there's one thing for certain, and it is that the regulators will ask us for more information. And it won't just be about the facts around the breach. And of course, they'll want to know that. They want to know how many people were affected, whether customers or employees or someone else, how many records, and what are the likely consequences, what on earth we're doing to mitigate. We can't actually provide much of that at all at the moment. But the thing is, they will dig deeper and they will be asking us what we've been doing to comply with our security obligations. So, for example, they want to know what security measures we had in place, because we obviously have high-risk data, right? What have we actually done to protect it from breaches of confidentiality, availability, and integrity? And they want to know whether we're actually following this sort of our policies and procedures, and whether we have controls in place. And they'll want to know, what we've done to prepare for this risk. I think it's good that we have these offline backups. They may think that it would be better if we could restore more quickly. But all in all, we just need to gather this information and present it in the best light possible. And if they find that we didn't put in place appropriate measures to protect ourselves from this kind of attack, I'm afraid they could fine us. And the level of the fine would really depend on how serious the breach is, how long it's happened, how many people are impacted, and what sort of damage they've suffered. And also what we've done to mitigate. And quite a lot depends on the level of cooperation we provide to the regulator.
One of the advantages of having external counsel involved in that process is that you can do that targeted document gathering exercise and have that conversation about how well you've done in terms of keeping your cyber systems and cybersecurity systems up to date, within a sort of a cloak of legal advice seeking, such that privilege will attach to those investigations and those sort of resolution of those questions.
Exactly.
Thank you, David. And Lin, have there been any fines for ransomware attacks? Is that something that is common?
I'm not aware of fines specifically for ransomware attacks, but there definitely have been fines for breaches of security.
Mm-hmm.
So, for example, in 2016, the FCA fined Tesco Bank £16.4 million for inadequate cybercrime controls, and also the failure to respond to a cyber attack with sufficient rigor, skill, and urgency. And last year, ICO fined British Airways £20 million for security failures. And that was for a data breach in 2018, and it involved the payment card data of 430,000 customers. And actually, that was a great result for them because their external lawyers managed to reduce the fine from the initial proposed fine of 183 million which is staggering. BA also had a class action claim and literally just settled it. And they had more than 16,000 claimants.
Wow, that's scary. Thank you, Lin. Back to you, Ioan, to carry on with the simulation.
Thank you very much. So yeah, the conclusion of the board meeting. They continue the investigation, obviously, and prioritize finding the extent of the breach because everyone is now under pressures we've already discussed, really. They asked the incident responders to see if there's a listing of the breach data from the dark web. You know, how the hell did the media get wind of this, assuming that internal staff didn't tell them, which feels unlikely. They use the external communications agencies to update press packs and give advice and communications to staff and clients and so on, and just basically refresh everything that's been done already against the latest information. Ask internal comms to monitor social media channels. Often, you know, people will try any and all means to communicate when the primary means are down. So that's becoming increasingly prevalent, and it's also a good way of discovering sentiment. You know, what's the chatter? What are other people thinking and finding out? Notifying the regulatory authorities through external counsel is something that definitely is going to happen very probably on Monday. And reinforcing the need for privilege and protection of documents also happens side by side. So just when things couldn't get worse, somebody in a hoodie turns up and the adversary gets in touch, which is really common at the moment, unfortunately, to say, well, why haven't you been in touch with me? We have your data. We're happy to release it unless you get in touch and you know, consider paying us a ransom, basically. Sometimes they're even approaching your clients before they approach you, which is awful because it doesn't give you time to prepare. It isn't the case in this instance, but it does happen. So how do you really assess that this is credible? The CISO had a thought at the end of the last meeting, really, which wasn't expressed, but you know, can we actually use the adversary to verify what information has gone missing? Can we ask them? Inevitably, there's somebody you can't really put that much trust in because they're trying to extort money from you. But at the end of the day, they're motivated to try and at least explain what they've got and its value. But you also need to be conscious that they might exaggerate that in order to extract a higher payment. So the incident response team really give advice to the CISO to contact insurance to authorize help from a company that specializes in negotiating with this type of threat actor. And they can help validate the claim, validate the group of threat actors. They maintain data on how much was demanded in various incidents, whether or not they managed to secure a discount against the initial demand, how credible they actually are. They can advise on their behavior, you know, how likely in past incidents were they to publish the data. They can help buy time through slowing down the process of communication with the threat actor to keep them on the hook longer, to try and prevent them from publishing damaging confidential information ahead of when you're prepared to deal with that outcome. And believe it or not, they can, to an extent, complete things like anti-money laundering checks, as well as sanction checks, if a payment is actually considered, and help with that conversion into digital currency as well. So they're pretty useful. And it might be about the only way of finding out exactly what's gone missing. IT come back with an update. So they now confirm that the data has been leaked. The incident response team accessed the dark web link that the IT director really didn't want to touch in the earlier ransom demand. There was a link to a hidden website, which could have contained anything, to be fair. But they validated the data against the corporate store. The logs and systems are damaged. It's really not possible, if ever, to see what left the environment. All they have is the firewall logs, which are pretty difficult to damage, but they just show a lump of data effectively leaving the company sometime on Thursday night before the ransomware was deployed, which caused the outage in the early hours of Friday morning. So they really can't tell what was taken, which is a nightmare. How do you then measure the impact of that? The investigation is still in its first stages, and the restoration plans are extending into the distant future. Because at this point in time, the team are trying to find out what happened, because clients will naturally ask that. It feeds into external comms, etc. The regulators will naturally ask that as well. Evidence needs to be preserved in order to answer those questions in time to come. But at the same time, they're trying to buy kit to restore onto and to put effort into building the business back up in a safe way and establishing probably enhanced controls to do that. And it's in the early hours of Saturday. Where on the earth do you buy kit over the weekend to be able to do this at any scale? So we're heading rapidly into the next board meeting, which is lovely and early on a Saturday morning. So the confirmation of the breach is obviously the main discussion point. It's verified that the published data is from the company, as I just discussed, and it's front of mind at this point. The board asked for the General Counsel to update them on the impact. The FCA probably need to be updated. Internal comms are going to be discussed. And external counsel obviously need to provide advice as well. So at this point in time, the feeling of panic is pretty palpable, to be honest. And the company needs to really sort out what it's going to do and how it's going to do it to try and limit the damage. So back to you, Kolvin.
Thank you, Ioan. David, if I could ask you first, you mentioned about potentially notifying law enforcement. Is that something we should now be doing?
I think it partly depends on what your insurer tells you to do. But I think prudence probably suggests that you do at this stage, and you probably would want to notify the NCA that the attackers have already shown that they have some data and that they're willing to release it. So in for a penny, in for a pound to an extent. There is another issue as well in terms of making a payment, because if you're going to have to use a conventional banking system, the payment may get caught with suspicious activity reports, and the firm, being in the regulated sector, may have to make a suspicious activity report itself anyway when it makes the payment, because it knows that it's making a payment to criminals. So on that basis, as a practical matter, you might want to, and probably are wise to, notify the NCA at this stage anyway, because you're probably going to need their help to get the payment away quickly if you are going to make one.
Thank you, David. And now that we know the attacker has released our information on the dark web, is there any action that we can take against the attacker, or is there any action that we should take in response to this information being released?
Yeah, so there's 2 or 3 things you can do there. The first is you can get, from the English court, you can get an injunction to prevent the attackers further disseminating the information and prohibiting them from making it public in any way. That has potentially limited effects, because if they're not in the jurisdiction, obviously they're not going to be subject to the jurisdiction of the English court, so they couldn't be prosecuted or brought before the court for contempt. But fortunately, we do have email addresses for them where that documentation could be served. The collateral benefit of that is that we can also obtain orders against web hosting and web service providers, which prevent them from making accessible, at least in the non-deep web, information which has been extracted and exfiltrated as a result of the breach. So you can get injunctions, for example, against Google to prevent them from allowing their search engines to return those documents when they're searched for example. And third thing, if we are going to make a payment, then we can apply to the court, obviously, for freezing orders to prevent the onward transmission of that payment once the hackers have received it.
Thank you, David. And Simon, now we know this data has been released publicly. How does that change our communication strategy?
Well, yeah, as the facts are starting to become clear, we will want to be kind of updating our media Q&A and putting some of the kind of answers in place. But more importantly than that, we will want to be able to consider updating our statements to kind of demonstrate that we are responding to this in a kind of robust and timely fashion, because ultimately we need to be able to communicate some degree of confidence to external stakeholders as best we can. The other thing that we'll want to consider is whether we proactively notify clients. Now, there will obviously be a kind of legal obligations that no doubt kind of counsel will have a view on, but we as a business need and we rely on the kind of trust of our clients, and therefore we need to kind of consider whether proactive comms is the best approach there. You know, a lot of these people are kind of high net worth individuals. They expect a kind of certain degree of kind of tailored communication. We'll also have to consider who and the best channel for that is. You know, is it one of our kind of account managers who may kind of deal with the client on a kind of frequent basis, or does the severity of this actually warrant someone more senior kind of making those calls? Of course, the board are very, very distracted with actually kind of dealing with the problem, so we'll have a kind of have to have a sensible conversation about where we deploy resources most efficiently. And the final point to make is that, as has been kind of touched on previously, there is kind of potential litigation that could happen around this in the future. So we want to ensure that any communication with clients whose data we have potentially lost, who could therefore become potential litigants, is done so in consultation with counsel and with that in mind.
Thank you, Simon. So Lin, could you shed any light on whether we have a legal obligation to notify, except Simon's point that we may want to do it as a business, but it would be helpful for us to understand whether we also have a legal obligation to notify individuals?
Sure. So under the UK GDPR, if the breach is likely to result in a high risk to those individuals concerned, then they have to be notified without undue delay. And the reason for that is, you know, unless they know about it, they can't actually do anything to protect themselves. That's the reason for notifying individuals, apart from sowing mass panic. But basically that risk assessment has to be made at the time when we as the controller, you know, is aware of the breach, right? We can't wait, we can't do sort of detailed forensic examinations for weeks and then say, okay, we're 100% sure now. We have to decide sort of early on. But of course, you know, if we've determined that we've got the right sort of security measures in place, such that there isn't a risk to the individuals. So for example, if the data had been encrypted and the attacker couldn't see it and we had our backups in place, then actually we could come to the conclusion that there isn't going to be a high risk to these individuals, and we don't need to notify. And in terms of, you know, in this case, whether or not we've met that threshold, I mean, just going back to what's happened, some sensitive data has been leaked, but we don't know who it belonged to, what was in it. So it's quite hard to determine the level of the risk. And really, we've got a lot of logistical problems here because, you know, we don't know which customers are impacted. I'm not sure that we have access to our customer lists. And even if we did go to our client relationship managers who probably have some of their key clients' data on their sort of work mobile phones, you know, what is the message that we're going to get these account managers to pass to them? Because I don't think it's particularly helpful to tell an individual that, you know, their data may have been breached and we don't know what it is, because we can't provide specific advice about how they can protect themselves. So for example, things like, you know, canceling credit cards if it was card data, alerting their banks, being vigilant about bank transactions. If we had enough information to know that they were at risk of identity fraud, then we could be talking about, you know, buying in some sort of monitoring and then offering it to them. So it's quite tricky trying to balance it up from that perspective. But I also think that since this has reached the press, our clients might be wondering why they're hearing about it through the press instead of from us. So perhaps some sort of basic notification to key clients would make sense.
Thank you, Lin. And with this new information, that some of our information has been made public, does that impact on our regulatory notifications?
Yes, of course. And thank you, everyone who came back to me on the wording of that notice that we had drafted yesterday. Of course, we'll have to update it now because of these developments, the leakage of sensitive data.
Thank you. Okay, Ioan, back to you to wrap up.
No problem. So unsurprisingly, the board decides to prioritize finding out what data has been exfiltrated. In this case, it really means exploring all avenues. So they continue discussions around paying the adversary to try and find out, because it seems unlikely that that data is going to still exist within the company. So they begin actively managing the external messaging in response to the grave worries around external reputational damage. And as we've discussed, it means balancing that sort of need to protect against future litigation, the impact of regulatory fines, with the need to give, fill that void, as Simon said earlier, and give people some information just to effectively buy time whilst the investigation continues. The need to give individuals a more involved notification at a future date is parked for now. And the board also considers things like finding out about compensating controls that could be deployed. So things like identity theft monitoring, credit monitoring, but that's kind of for deployment in the future once things become clearer, and that can all be sorted out properly. So the more immediate communications that are personalized and perhaps go through account management to high net worth individuals, etc., are probably the priority in tandem with the need to advance the investigation to find out exactly what's happened. So thank you for accompanying us in the initial phases of a ransomware investigation. But I'll hand back to Kolvin for any final thoughts. Thank you.
Thank you, Ioan, and I'll be quick because we're at time. But I think the most important takeaway from this simulation is to prepare. So it's about knowing who your incident response team is in the event of a breach, whether it be a ransomware attack or some other type of breach, and documenting that in an incident response plan. And it's not enough to have a plan. As Mike Tyson once famously said, everyone has a plan until they get punched in the mouth. So what's key is that you practice, 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 and practice. And this is part of this is part of your sort of practicing exercise. So I think we're at time now, and so I just want to say thank you so much to our panelists for this excellent simulation. I hope you all enjoyed it, and thank you so much for attending. And enjoy the rest of your afternoon. And good luck to England on Sunday. Thanks, everyone. Bye.
Thank you.
Thank you.